So welcome everyone. I hope everyone's signed in.
I have a
We do.
paper somewhere.
Where is yours? On the counter.
Where is this, David? Right over there. Look, we're all
sign in.
So let me read the agenda. We have 2 items of new business. A request by KCS LLC, CF Trust, and Kingdom Ventures LLC for a conditional use review for the development of the fourplex. And that property is at 20 Morgan Road in the low-density residential zoning district. And then we have a request by Leslie Dunn and Cody Marx for an appeal related to a zoning administrative action. So I want to remind folks that this is a quasi-judicial proceeding. We're going to conduct it informally and polite manner. I'd like to start by asking members of the board if there are any conflicts of interest.
No.
All right, that's good to hear. And then comes the boilerplate, the interested party language. An interested party is the applicant or the owner of property, a person owning or occupying property in the immediate neighborhood, or someone who can call an impact from what will take place, or any 10 persons decided to issue the DRB. The reason this is important is only interested parties can appeal decisions of the DRB. We don't decide who's an interested party, but we do need to know who's here, which is why we ask you to sign in. And also we ask that when you speak to, please give your name. Now, I'm going to have to read a statement that you guys have to swear to. Sorry, didn't expect to be sharing this meeting. So, I'd like to, excuse me?
Oh, I'm sorry, just speak.
Yeah. I hereby swear that the evidence I give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury. What do you want to say I do if you're?
I do.
You do? All right. We are going to start with item 1, and Chris, if you can give us a bit of the background of it.
The history here in the project is, originally the application was made in 2016 for 3 duplexes on the property with an allowance for a 50% density bonus. The DRB reviewed it. The DRB did not grant the 50% density bonus, so the application failed and was denied. That application was appealed to the environmental court. The environmental court basically asked for mediation. The parties mediated and came up with a settlement agreement that allowed the project to move forward, and it would consist of 3 duplexes with 1 duplex being perpetually affordable. The applicant pulled permits. I have to go back to my notes, but I believe they originally pulled permits that sunsetted, and then they pulled new permits on the same, basically the same court decision agreement. In 2023, they began to commence construction on the project. It's still under construction. In the spring of 2024, the applicant came in front of the DRB for a sketch plan review of an application. And basically the DRB provided a sort of a memorandum of here are your next steps for you to be able to accomplish to bring a new application forward. That received a certain, that was appealed to the environmental court. The environmental court basically threw out the appeals because it really hadn't gone through a review process, because sketch is an informal process where there's no formal decision being made. And basically, one of the jobs of the DRB is to provide guidance through the sketch plan review, which was the memo. So now we have an application that basically is being requested where we have a project that consists of 3 duplexes. They're going to provide a connector between 2 garages, and they were calling that a fourplex. The board will need to do Stowe Highlands Hildebrand test, because the original project was denied, to see if this is substantially different. And then it would carry, if it isn't, carries forward. If it isn't, then basically the project doesn't move forward. The applicant can basically, present their project and how it's substantially different, and how it passes that test, and then the board will have to, my recommendation would be, to deliberate at that point. So we clear the room, we talk about it, and we either say, yes, it is substantially different, or no, it's not. So that's sort of the overview in a nutshell.
And if the decision is that it's not, that will be the end of the hearing. If the decision is that it is substantial, we'll then ask for more detail. So I apologize that we're going to kind of cut things in half and kick people out, but we promise we'll let you back in again. So who wants to speak for the applicant?
I can actually, and I think it'll be pretty brief.
Can you come up here and sit here?
Say your name.
And introduce yourself, please.
Hi, good evening. My name is Christian Chorba. I'm an attorney at Downs, Racklin, Martin in Burlington, and I represent KCS LLC. I was recently retained, and what I would like to say is we are actually we are withdrawing this application. That was to be considered tonight. So we have no application before you tonight. And I could give you just a few reasons why. It does seem that procedurally, just within the past few months, there has been quite a bit of shakeup in terms of the zoning regulations. So we just want to make sure that we're proceeding under the correct zoning regulations. My understanding is that they were recently amended, and there's a little bit of confusion about exactly when the applications were deemed submitted. And which,
Can I ask, where's the confusion? Is confusion on your side?
the confusion is just that we're not.
Where's the confusion? Is it from the applicant or the town? Because the town's not confused.
Okay.
I think it's better if you just.
No, I'm asking a question, so.
Well, so it wasn't clear to me exactly when it was deemed submitted, our application. There's also a question of, in any case, we're withdrawing these applications. They're withdrawn. And I'm just letting you know that I'm looking forward to working with Chris Flynn, with town council, just to make sure that all procedures are correctly followed in terms of any, next application that we submit. We just want to make sure that, is substantively correct as well as 100% procedurally correct. And one other thing that I noticed and that I was a little concerned about is just whether or not sufficient warning was sent out. I'm just seeing that notice of public warning was sent to abutters on the 11th of this month. It has to be sent out 15 days in advance. So that wouldn't be sufficient. So if we had any abutters, come out of the woodwork, so to speak, a week or so or whatever down the line, anything discussed tonight could essentially be null and void because proper notice wasn't given. And another thing I think in working with Chris on our subsequent application, one thing I want to make absolutely certain is that we're following the forms properly. I'm just noticing, I think that these forms, I don't know if the solution is to update the forms or whether it's to put in our own annotation. I'm seeing things like the zoning districts. I don't think they've been updated. I'm not seeing an update reflecting the more current zoning regulations. So I'm not sure which zoning district, for instance, we would select. So that's just an overview of some of the issues I've seen. We've withdrawn the application or applications, if it's considered two, on notice for tonight, and we will be submitting a new one very shortly. And we look forward to presenting that one to you in hopefully a few weeks.
Thank you. And thank you for pointing out the issues which will affect.
Yes, and as I mentioned, I look forward to working with Chris and with town council just to make sure that whatever is in front of you is perfectly, complies with everything substantively and procedurally. Okay, thank you.
Thank you very much.
Thanks.
Okay.
Okay, so the second item on the agenda is also going to require a little bit of background from Chris. It is not something that we have seen before, or at least I have not, in terms of something the DRB rules on. So I'm being very candid here that I need to learn a little bit more about the procedure, and hopefully Chris can clarify that.
Well, basically, technically, any decisions that I make has the ability to be questioned or appealed. And, the, appellant, Cody Marx and Leslie Dunn, felt that I, made a determination that they filed an appeal on. And we are here to, hear what my determination was and what they're appealing. And then the board will, either rule to, overturn the appeal or affirm the appeal.
So I guess the one thing that I need to ask with you is there's no definition for what is the determination versus what is a response.
Well, I guess I determined, I'm sorry, go ahead.
Yeah, and you had mentioned that you talked to the town attorneys. There's something that we have in writing that can explain that.
Usually it's a ruling that the zoning administrator makes that would be the determination. And so, it's a sort of a defined, or declared ruling on this is a violation or this is one. The communication with the town attorneys just via email, those can be shared with the board. That's fine, and they're not public because it's attorney-client. But they can be shared with the board because I'm an administrative officer for the town, and you guys are the adjudicators for it, so.
Now, I don't know how else feel about this. Again, this is somewhat new procedurally
It's something new to us.
to us, yes.
I don't think it's new.
No,
Yeah,
correct.
we've had zoning administrative,
Yeah.
determinations that have been.
Yeah, I mean, you might.
Yes, but the question of what is the determination, I
Oh,
think
But
is,
how did you form your determination? Did you cite sections of the rules or stuff like that?
No, I basically, my stance is I never made a determination. And they're appealing something that.
But we need to determine you didn't.
Yeah, we should hear from them as to what my determination was.
I would like to.
yes,
And so I think that's what, and that was sort of the discussion with the town attorney. Was it made more sense to carry forward because what I perceive is maybe not a determination, may actually be a determination. So it's in fairness to them to hear, how I did something wrong.
in that case, whoever would like to speak. Please come up. Thank you.
Marty Marx and Leslie Dunn. And we have
What's that?
a handout for the board members.
What is it?
Communication indicating decision making.
I think we have copies of the emails, but we should, this is the same thing that.
Wait, what if your determination was based on one of those editions?
That's, this is information that the board can look at, you really determine, or, I mean, it's history is what it is.
Yeah, that's right. Can I, this point of clarification, are you saying you haven't seen the complaint?
Yeah, they are.
Oh, you have, okay,
No,
okay.
all I'm saying is the question of what is the determination
Okay,
is
so
something
that's fine.
that is new to me and.
Okay,
I've been doing this since
But traditionally, if I cited a section of the regulations and you felt that I got it wrong, you would be saying that my determination on section X, Y, and Z is incorrect for these reasons. So, so obviously you felt strong enough to file something and you can tell the board, what I determined and where we're at.
thanks. Thank you. So, hello. Having lived peacefully on Old Pump Road for nearly 35 years, we never envisioned ourselves being in such conflict with our neighbors or with the town. And we all existed amicably with the previous stand. until the business grew and grew, and the traffic grew and grew, and the cars and the pedestrians kept on coming. So now we're looking for answers from the DRB because we believe there are regulations that haven't been enforced and permits that haven't been granted. We brought our issues to Chris, the zoning administrator, and he had three options. He could find a violation, find no violation, or find a violation but exercise his discretion as to enforcement. And in our cases, Chris as zoning administrator declined to issue any notices of violation. And in each case, a finding of no violation is an appealable decision. So that's really why we're here. And it's unfortunate it has come to this. But I was going to talk about the first two violations.
So we submitted 3 violations, so I'm going to talk about the first 2 regarding parking. Back in 2013, the Palmers did get a parking permit for 4 cars by their barn, but it now holds 6 spots. So that's a violation of the permit issued in 2013. The second parking violation that we see is that across the street from that parking area, there are 9 or 10 spots that are parking for the cream stand. There's no permit for that. Plus, with that parking and the parking by the barn, those cars are backing onto a public road, Old Pump Road, and that is in direct violation of the Jericho regulations, which state parking areas shall be laid out so not to require or permit vehicles to back onto a public way. So not only are there 2 parking areas going on the Old Pump Road, but they're backing into each other. And so we had asked Chris, we thought that was a violation he issued. He said that was not a violation. But those are the first 2 the first 2 violations. In response, that Chris sent to us, he said that the parking spots across from Creamies is owned by someone else, if I'm interpreting. First of all, it's being used by the Palmers, but it doesn't matter who owns it. It's creating a parking that's violating Jericho regulations around going onto a public way. Also, Chris suggested that because there's a parking lot application on file, that doesn't negate that the violations currently exist. They are ongoing every day. And the parking lot application has not been approved. We don't know when it's going to be approved. It's the parking lot is part of an Act 250 designated property. So it's going to take some time. So the fact that there's something pending over here doesn't negate that violations are occurring, and they're occurring today. So those are the first 2 violations that we see. They were non-determinations of a violation.
The third one has to do with the permitting of the business and the ongoing changes to the business over time. So this is not a new issue. We've been trying for a long time to hunt down the permits for the original permits for the business, and have been unsuccessful. The handouts that I gave you show a little bit of the history. One is a letter from Chris to Paul Palmer, the owner of Palmer Lane, one of the owners, about the retail commercial operation on Old Pump Road, and mentioned that I was not able to find the actual granting of the retail operation, but the previous zoning administrator was aware of your operation and granted a zoning permit sign permanent for your business. Taking this into consideration, I am assuming when the permit was granted, it also took into consideration your business operation. that's as close as we've been able to come to a permit is that we can't find, nobody can find the permit. Similarly, in 2023, Cody and Chris both had an exchange, still wondering whether the zoning permit had been granted for the retail operation. And Chris's response was, we have looked in the issue and there's not much in the town's file to show. And that there's a permit, and stay tuned. So the permitting is a little bit like smoke and mirrors. Because there is no history or there's no record of the permit having been granted. And so then comes, so I guess that is one question, Chris, for you that you had told Cody you'd get back on, is whether you found the permit or not. And that was in 2023, so it's still for us an open question. And then, as the business has changed, as time has gone by, we've all witnessed the Palmer's retail operations morph into something more that fits this definition of a restaurant. A commercial establishment whose principal business is the sale of food and beverages cooked or prepared on the premises, and which may have facilities for either on-site food consumption or takeout service or both. So if you look at illustrations from Palmer Lane's website and Facebook page and from the facility itself, you can see it's all about confections like creamy cakes, creamy pies, creamy cookie sandwiches. It's about ice cream. And this particular operation has a menu that lists all the different food options that Palmer sell. And so it's, in addition, the facility has got 26 seats for their customers, and the menu posted outdoors. So our argument is that it's a restaurant and needed to be permitted as such. And it requires a conditional use permit, which has not been, which Chris didn't respond to when we brought that up in our July, our July complaint. Yeah, so you want to explain this part?
Right, well, probably better explain, but Chris's explanation for the third point was that this letter shows that the Palmers have a permit. And we were like, this does not show that the Palmers have a permit. This shows that you think they have a permit. This doesn't show it.
So Chris's thought is, this issue has been resolved in 2017 when this letter was written, and the issue was not addressed this particular issue was not addressed in 2017. And it's a very different business now. So tonight we are asking the DRB to make sure that regulations are followed and violations are addressed and issues are permitted. And that's what we're asking.
Do board members have questions?
You said they have 26 seats there?
Yeah,
Where?
in the front yard, in the side yard, on the porch.
How like?
Yeah, all those benches.
Is there any inside?
I don't think so.
No.
No, all the business, all the seating is outside.
Kind of like Kate's.
Yeah. It is kind of like Kate's, and really, we're asking for a conditional use permit, just like the ones the board granted Kate's.
We'd love to know if there's a permit.
Now, procedurally, Chris,
Yes,
is that something that we are capable of doing without a written application? again, and forgive me, but this is procedurally, this is different from what I am used to.
So,
So bear with me.
so I think the process would be is if you agree that there is a violation, then basically the DRB essentially orders me to issue a notice of violation. So, and that's something we can discuss in deliberative meeting.
Have they brought up stuff that they didn't bring up before, like
Who's
this,
the stuff that they did?
like the feet, like you got brought up in, or.
No, I mean, we know that there, people sit outside and eat there. I didn't know there were 26 seats or
So
supposed
I'm
to
just
be.
saying, really asking you to act on certain violations. You mentioned a lot of stuff tonight.
Well, their points are within the materials in that submitted.
So that.
And is it true that the original permit has been lost somewhere in the?
The record shows that they got it, the record shows in 2013, the zoning administrator issued them a sign for basically a Palmer's League, creamy business, and there is not a use permit, but the zoning administrator granted the sign permit, which basically I ruled that he must have known that's what they were going to be doing. I received information from the owners that that's what they were told to do. They did what they were told to do. And then in 2017, when the question was being asked, wherever, and I couldn't find it, I just relied on the previous zoning administrator and what they ruled and determined at that point in time. I didn't, didn't second guess it, or I don't second guess it. There are permits that have been granted that I'm not sure how they got granted, but they did. And there must have been reasons. So for me to, essentially 4 years after, come back and say, you need to get this. This has been discussed with town council as to options and things along those lines. So, we haven't changed our stance in that time period. So. And this appeal is different than what the board heard in regards to reviewing the application of the an applicable big road deals with the same property, potentially same issues. So
that 2013 sign permit had said there was a spot for 4 cars.
I'd have to go back and look. I mean, I don't remember off the top of my head. If they say this says 4, that's fine. We had testimony tonight that basically it's 6 cars. There's written testimony they provided that 7 cars. Are the spaces delineated? There is some marking in that area. The exact number, I don't recall off the top of my head.
6 are marked.
Yeah.
There's a picture of it. We filed it with the appeal.
I'm sorry, could you?
Gravel parking.
Yeah.
It's not like painting or anything.
Well, there's demarcations on it,
Other board questions? Anything from members of the audience? Yes, and please come up to the table if you don't mind, or just project.
And if people are gonna comment, they should comment with regards to the appeal, not.
Right.
Because that's what we're discussing.
Hi, I'm Beth Lemus. I live at 87 Old Pump Road. I just wanted to clarify a couple of issues that they explained everything very well. I've been a customer of Palmer's since they opened. I used to buy cookies there and maple cream. They didn't get an original permit for creamies. They did not have creamies at the beginning. They had a retail store where they sold maple candy, maple cookies, maple cream. The creamies were developed later to enhance their business, and the creamies have taken over their business, really. The creamies, and I think they've even testified at one of these hearings that the creamies are the major source of their income. So their business has morphed, and with their business morphing, the traffic has morphed. And I want to focus on the traffic and how unsafe it is to have vehicles back out into traffic. Because there are 10 spots on the side of the road that's owned by the Von Turkoviches. I think it's an LLC that owns it. So maybe 2 permits are needed. Maybe they need a permit for the additional parking spots on the Palmer side of the road, and they need a permit for the 10 spots on the other side of the road. People back out all the time, and people treat that end of the road as if it is a parking lot. I think we've all who are here have had the experience of people stopping, letting out their customers because they're waiting for a parking spot and they run across the road. I almost hit somebody running across the road in front of me while they were waiting for somebody to back out of a parking spot. I think there's been testimony in other hearings that there's been emergency vehicles that have tried to go by and couldn't. But basically, backing out into the road is in the Jericho regulations because it's really unsafe. And they have all their spots backing out into the road. And there's not just us who's upset by it. I believe there were 45 people who signed a petition asking for a traffic study because we are all really upset with the way that people back out into the road and affect the traffic. If this has not been going on for 15 years, there's no statute of limitations problem. We've requested, because it's been increasing all the time and it's gotten to the point where it's really boiling over, we've requested, or they did, that, not me, that there be a notice of violation issued so that they have to come before you, present their application for a conditional use permit, show that they meet the requirements, which would be safe parking, before an accident happens. And there have been accidents because I live on the road and I hear the sirens go by. I did not request a copy of the accident report from the state police, but I suppose in that we might show how many accidents have happened at the corner of the road. There's going to be a serious one at some point. And if it's not a safety issue, it shouldn't be in our regulations. If it's not going to be enforced, it shouldn't be there. It shouldn't be enforced with some people and not with other people. And I look at Kate's as an example. Kate's has a conditional use permit. If you were to look at Palmer's is more like Ben & Jerry's than it is like Old Navy. People don't bring their, Old Navy is a realist, is a retail store. You don't sit outside Old Navy and look, and I get to enjoy your purchases. I mean, it's Ben & Jerry's, what it is, and they should get the same permit that Ben & Jerry's would get. That's mine. Thank you.
Can I ask Chris a question? Chris, if the prior zoning administrator had granted a permit, wouldn't that be in a file someplace?
It should be, but I mean, that was in 2013. Unfortunately, records.
Let
me finish answering your question. You may not like the answer, but the records come and go, within the file. And so looking at the file, is there a specific permit for a retail establishment for Palmer's? No, there's not a use permit called out in the file. Should there be? I guess that would be left up to the zoning administrator at that point in time to make that call. So
there could be.
That would be left up to that zoning administrator at that point in time to make that call.
So there could be a permit for parking, but not a permit for the business the parking is for.
That's history. I can't go back to tell you what they did or why they did it.
Okay.
So.
Any other comments from the audience?
I would like to resubmit the petition, the 40 Old Pump Road members signed for an accurate traffic study to be done.
I believe that was part of.
That's the application in that file. This is dealing with the appeal, so it's probably not appropriate, but it is, the board has it. They're made aware of it.
We have noticed.
Okay, that's great. Any update on that?
No. Does anyone online have any comments or questions?
You need to raise your hand, please. Doesn't look like it.
Sorry, I don't. Thank you.
I'm Beth Albright, and
You need to show up your name, please.
I live at 675 Old.
675?
675.
I'm sorry, you're Beth?
Beth Albright.
Thank you.
Yeah. Since this is about the parking on both sides of the road, is that zoned commercial, Old Pump Road?
It's Village Center.
It is residential on Old Pump Road. Those are all residences. But the parking is invading residential? I mean, it's a business that's running down a residential road.
We're gonna have to look at exactly where.
Okay.
Yeah.
I would like to raise that issue and not discuss it further, but to me, it's a business that's crawling down. And its parking is on the residential, I don't know, is there a number of feet that's?
It falls within the village center, village center zoning district, and it has a multitude of mixed uses. It's not all residential. It can have businesses, it can have commercial operations, it can have retail operations with. Yes, and that, yes, because it's a blanket area. Old Pump Road is not its own specific zoned area. The area, which includes Joe's Snack Bar, the gas station, the mill, the residence, the Ale and Bean, Snowflake, the post office, the school, all those fall within the same district. So there are that number of uses that are allowed in that zone district, which includes Old Pump Road. Up to the bridge, and then past the bridge is, I believe it's probably rural, agricultural, residential, which has a different list of uses that are allowed in that zone district.
That's it.
Thank you.
Thank you.
One more?
Yes. Andrew Albright, also of 675 Old Pump Road. Point of clarification from Chris, if you would not mind. So
I'm not sure I understand, not yours?
I'm asking if you wouldn't mind asking.
Okay, yep.
The clarification that I want is that apparently there was some discussion of a previous administrator issuing a sign permit. Is that the permit that was issued?
That's what I said, yes.
Sign.
For a retail establishment, yes.
And did the sign include paintings?
I have to look at the exact permit to see if it's paintings or not.
And you didn't bring that information with you tonight?
It's upstairs,
Why did you not bring it with you
but I
tonight?
didn't think it was relevant.
Why is it not relevant?
We're dealing with
This is the very issue we're dealing with, isn't it? Is the fact that we have some ambiguity about permits. And the town, in the person of the zoning administrator, doesn't appear to be on the ball.
all right, that's nice. It's a retail establishment.
Got it?
That was for the sign. What they're doing falls underneath retail, not restaurant. So it's allowed,
And that is a determination by you?
as well as the definitions, and the board will end up hearing those points, and they'll either say, I'm wrong, or I'm not wrong.
Okay,
That's
the clarification that I needed right there. Thank you very much.
I have a copy of the sign permit if anybody wants.
You shouldn't, I mean, yeah.
You have it in your file. You want it?
We'll get it, but thank you.
Okay.
All right. We have a lot of thinking to do here.
You do.
So I'm going to close the public part of this meeting and thank everyone for their patience and hope that you'll appreciate that this is going to take a little bit on our part. Really appreciate everyone coming forward.
Thank you.
The only other item on the agenda is approval of the minutes. Most of them have a chance to be able to that. I will say that I want to change the recording secretary was unable to determine the name, so we spoke or refer to him as a female. Refer to him as a refer to us. Right. Clarification.
You have a line number?
Oh, thank you. Twice.
I'm sorry?
It was close.
Okay.
54 and 78.
What the store closed?
Yes, please.
Yes, please.
Thank you. Those have any questions or comments? And if not, do I hear a motion to approve the minutes? All in favor? Aye. And I'm going to move that we Adjourn or close?
We close the public meeting, we're gonna go into, the deliberative, and so I'm gonna ask everybody to leave, and I'm gonna turn off the recording.